Hello, everyone. Thank you for tuning in today. Welcome to It's Time for More Injury Funding, the podcast for all who want to learn about legal funding and its significance in the personal injury, workers' compensation, medical malpractice, trucking law, rideshare, and many other types of law practice domains. I'm your host, Laura, founder and CEO of More Injury Funding, the legal funding counselors with passion for law, medicine, legal funding, and heart for all suffering individuals. In today's episode, I have an honor to talk to the attorney, Jeff Laffey, president and co-managing partner at Laffey, Bucci, DeAndre Reich, and Ryan LLP, based in Philadelphia, Pennsylvania. Today, we'll be diving deep into the topic of balancing the scales, how civil law empowers injured workers. At the end of our episode, I have prepared a fun pop-up question for our guests, so stay tuned. Welcome to my show, Jeff.
It's a pleasure to be here, Laura. Thanks for having me.
Absolutely. So, to start our conversation, can you share a little bit about your background and what inspired you to focus on representing injured workers, particularly in the construction industry?
Sure, I'd be happy to. So I'm a Philadelphia boy through and through. Lived in Philadelphia and the surrounding counties. Was educated in Philadelphia. I went to St. Joseph's University undergrad, Villanova Law School, and then received a Juris Doctorate in trial advocacy at Temple University. So Philadelphia has, the big five schools. I almost covered all of them, but maybe someday I'll get to Drexel and UPenn for some further education.
I love it.
Um,
Wonderful.
you could say I was sort of preordained to do what I'm doing in my career. What I mean by that is I represent injured union construction workers. At least 95% of my cases are workplace injuries, most of them catastrophic. And it seems to be like my life's mission to have done that. My background, I am a son of a union carpenter. My father rose up through the ranks in positions of leadership, and he was essentially the number two guy in the Philadelphia Regional Council of Carpenters. And I grew up on the union dime. I share the same values as the middle class workers, the men and women of the union. I've supported their causes. They're my causes, walking the walk my entire life. So we bought American products. We supported all the union causes. But the one thing that separates me from all of the union men and women that I represent is that they're actually handy, and I'm probably the least handy person you'll ever meet. And so, to make a very long story short, I knew where my talents lied, which was advocacy, and I'm passionate about that. I do remember a time in my childhood where my mother was obviously stressed, and she was on the phone and she was whispering, and I was, fourth grade perhaps. And it was right before Christmas. It was like December 23rd. And I can tell my mom was stressed. And a couple hours later, my father knocks on the door and there's rustling at the door. So I go to open it and there's literally a Christmas tree over his shoulder. But what I remember is this eye patch over his eye, which I come to learn that a nail from a nail gun ricocheted and got him in the eye. It was a very close call. It got him just under the eye. So he had to get medical treatment. But what I'll never forget is like this moment where I froze and I saw my father wearing an eye patch and he said, "Stay in school, kid." And that to me was like the path. It started that day when I was young, where I just said, I don't know if the trades are for me, but I sure as heck would want a career where I'm surrounded by my people, so to speak. And I've been doing it, you blink, and I've been doing it 27 years now. And so I've been very privileged and lucky. And it's an awesome responsibility to represent an injured construction worker who, in a moment's notice, has their life turned upside down. And the reason they have their life turned upside down is because they're sustained a serious injury at work. And the reason they sustain a serious injury is that the bigwigs on the job, the general contractors, perhaps even product manufacturers, they take shortcuts. the value system is flawed. Profits over safety is a recurring theme. It's a necessary ingredient into something bad happening on the job. It's rushed. It's things like a failure to plan. It takes time to make a plan for safety, and oftentimes we find that the contractors don't do that, and as a result, bad things happen.
Mm. What a beautiful and touching story, Jeff. Thank you so much for sharing it with us.
Sure.
You've built a reputation for aggressively fighting for workers injured on the job. Can you walk us through some of the key legal challenges that injured workers typically face in the construction cases?
Sure. I think maybe the best answer to the question is, I think you phrased it as legal challenges. I think most of my clients first have to overcome some human challenges. And what I mean by that is we're all human beings. And when the people who are responsible for safety on a job, when an accident happens, they look to deflect. It wasn't me, it was them. It wasn't me, it was them. It was not my fault, it was your guy's fault. And so, first and foremost, from a human perspective, my clients feel somewhat abandoned, right? I mean, they get injured at work, they're not prevented from returning to work, and the phone calls after day one and day two, they end, right? And now that person is just another statistic. And those companies say, all right, well, we'll report this to our insurance carrier and let the chips fall where they may. So oftentimes, one of my biggest hurdles is and it's not my hurdle, it's their hurdle. We humanize them and we say, we understand what happened to you. Of course, after we carefully investigate the case, oftentimes we find that the entities that were responsible for safety, the entities that got paid the big bucks, the entities that submitted a bid to the owner of the project and said, safety is our number one priority, and we will be proactive with safety, and we will eliminate unsafe conditions, and we will eliminate unsafe acts. And we will do all that because we'll be proactive in inspecting the job as it's being done. And oftentimes we find that that's just talk. They don't walk the walk. They sure as heck talk the talk, but they don't walk the walk. So first hurdle is just to get these guys on board with fighting the fight, right? Seeking justice, because they come into my office feeling as though they did something wrong. And oftentimes they may have, didn't have the fortitude to say, listen, I can't do this. This is not safe. Or they don't have the appropriate tools or the appropriate plan to attack something. And oftentimes our position is, listen, we do this day in and day out. We recognize your concerns, but the legal challenges, leave that to us because we can navigate that. So it's the legal stuff doesn't really impact our clients. We got their back on the legal stuff. And I'm proud to say that in addition to the legal fight, we're with them every step of the way. For whatever reason, the easy stuff becomes the hardest stuff for a lot of personal injury attorneys. They tend to forget the human element, right? So if I have a guy who's on his 1-year anniversary of a serious accident, he's going to get a call from me saying, hey, I'm thinking of you, right? So it's the human challenges for them. The legal stuff, like I said, we got that. What are those legal challenges? I mean, in its essence, finger pointing, right? The defendants in their case simply say, it wasn't us, it was you. It wasn't us, it was you. If it wasn't us and it was you, it must be your employer or it must be something else. And that's where we make our living, because we get as the rules, as allow us to put these people in the hot seat otherwise known as a deposition, ask them questions under oath, present evidence to them, and that evidence oftentimes looks like the things that I previously mentioned. Their contracts, their bids, all of the things that they said that they would do for all the big bucks that they're earning. And then we show them that the evidence is that they were just words. They were empty promises. So again, not to sound like a broken record here, but we don't necessarily, we shield our clients from the legal hurdles, and we take them on. But as a practicing attorney, clearly, as I mentioned, they point the finger at our client. They point the finger at his or her employer. They deflect attention off of themselves. And, they have other legal challenges like, for instance, oh, well, your client's responsibility for the happening of the accident exceeds ours. Your client's share of responsibility is over 50%. So under the law, they would not get a recovery. And, when you get them in the hot seat and you remind them what their legal duties were in the first place, and you get them in the hot seat and you can prove to them and to their lawyer's satisfaction that they dropped the ball, that's where cases are won and lost. And we do our jobs right, and we turn every stone that needs to be turned. We dot every I and cross every T. And so, at the end of the case, we can look a jury in the eye and say, this is why this accident happened. And the buck stops with these contractors who failed to do their job, failed to fulfill their promises.
These workers in Pennsylvania are blessed and happy to have you, for sure.
Thank you. Thank you.
How does civil law function to help level the playing field for workers who are often up against powerful corporations and insurance companies? Can you share maybe any specific examples where civil law has made a significant difference for a client?
Well, sure. So let's start with how the relationship of attorney-client is formed in not only Pennsylvania, but in, I believe, all states. And that's formed with what they call a contingency fee agreement, right? So I'm going to say safely that 99% of every client I've ever represented in 27 years, and I say this respectfully, but they would not be able to afford paying me and the lawyers at my firm an hourly rate for our time, right? And so the law allows us to enter into what they call a contingency fee agreement, which means we can take a percentage of the recovery so long as our firm advances all of the costs of the case and takes all of the risks, all of the financial risks. So if there's a change in the law or there is some unforeseen and unfortunate development in the case that either ruins the case or a judge dismisses the case on some type of area of law, all of the money we spent, whether it be $100,000, $300,000, and by the way, these cases aren't cheap, all of that is just on us, right? And so there's never a time where our clients come out of pocket for anything, not even a penny, even in the investigative phase, right? So if we take we agree to investigate a case on behalf of a client, we may spend upwards of $10,000 to $15,000 hiring experts, taking them to the job site, hiring experts, having them inspect the product at issue if there is one involved in the accident. And so at the end of the day, we may determine there isn't a cause of action and we just eat it. It's the nature of what we do. But again, I think the contingency fee agreement arrangement really is the great equalizer. It really evens the playing field because, let's face it, these big companies with a ton of resources hire even bigger insurance carriers to defend them and insure them. And they have billions of dollars, right? Billions. All the resources in the world to throw at us and in the defense of their case. So I liken it to a David and Goliath kind of story, but our rocks are big and we have good aim.
I love it. Beautiful. Your law firm is OSHA certified, OSHA, which is quite unique. How does
Yeah,
this certification provide an advantage in handling workplace injury cases, and what specific knowledge or skills does it bring to your practice? And for those who forgot what OSHA means, is Occupational Safety and Health Administration.
that's correct. In 1970, OSHA was formed, and it really serves its purpose, at least in establishing minimal safety standards for all scenarios at work, hence the word occupational. From my perspective, you asked the question, is the firm is OSHA certified. So maybe better stated, the lawyers, including myself, that handle the workplace accidents, they all have received OSHA 30 training. And then we've gone even further because a lot of our cases involve products and a lot of those cases involve forklifts. So we are also certified in safe forklift operation. And that has been a tremendous benefit for us because most lawyers know that they are the jack of all trades, but a master of none, right? That is to say, they get a call from a client, hey, I was excavating and the trench collapsed and my coworkers and others were temporarily buried as a result of this collapse. And what most practitioners do is that they say, well, I know next to nothing about that, but I'll call an expert to get me smart. And that's fine. I mean, that's what 99% of the other law firms do. And it's sufficient. But I think my firm goes the extra mile because those experts aren't going to be with you, sitting next to you when you're taking some key depositions, right? So we already have the know-how. We've invested that time and resources to get smart. So we can, in consultation with our experts, but we can walk the walk with them in the deposition room when it counts. And to me, that has been such a measurable difference between my firm and the other firms in this space. Where, for obvious reasons, the lawyers may not know the questions to ask because, again, they don't have their expert sitting next to them in the deposition room. So, in essence, we want to become the expert. And, listen, at time of trial, you need an expert, but it serves our purposes immensely when we're in the war, in the trenches, taking their depositions. We know this stuff inside and out. And I think it's clearly a huge benefit to the client.
100%. And do you only handle cases within Pennsylvania or you also travel outside and nationwide?
Sure. We travel outside Pennsylvania. A lot of firms have workplace accident divisions within them. And so, it's not that often where we're called to different states to serve as experts. And I hope that changes. I feel as though we're well equipped to do that. I know that when we were sort of chatting before this podcast started, I touted our crime victim division, and they are definitely more nationwide than the workplace accident division.
Good to know.
And from my perspective, a significant amount of our cases come from Pennsylvania attorneys for accidents that happen in Pennsylvania, New Jersey, Delaware, essentially the Northeast corridor of the country.
Very good.
Yeah.
Why is it critical for attorneys in your field to stay updated with evolving safety standards? Can you discuss how changes in OSHA regulations can impact your approach to a case?
Sure. I mean, as I said before, OSHA sets sort of the floor, right? They're minimal standards, but it's law, they're requirements. And that's the the real punch of OSHA is that it's a law, right? It's not just recommendations. They're saying this is what you must comply with. This is the minimal standard. And OSHA encourages employers to set their standards much higher, right? And so it's nice to have at least that, a floor. And oftentimes we find that in our cases, that floor hasn't even been met. It hasn't even come close to it, right? For instance, on a construction site, there's a necessity sometimes to build holes, to create holes, to run conduit underground, to create holes.
Sure.
And so it stands to reason that when those holes are not being actively worked on, they need to be covered, right? And there's OSHA requirements that say, here's how you cover a hole. And that requirement is you got to put a piece of plywood down there that's sufficient to hold any force that goes on it, whether it be a high reach that drives over it or a big guy walking on it carrying a bunch of tools, whatever the case may be. But that cover also has to be nailed down and secured to the ground so that a wind gust doesn't pick it up, right? And that whole cover needs to be conspicuously marked as hole cover.
Mm-hmm.
Those are the minimal standards. They make complete sense. That's supposed to serve their purpose of covering a hole to prevent somebody from falling in that hole. Laura, I can't tell you how many cases I've handled where a construction worker was tasked with cleaning up the site or tasked with gathering materials for an upcoming assignment. And they go and pick up a piece of board that was covering a hole, but they didn't meet those requirements. They weren't nailed down. It wasn't marked hole cover. And the guy goes to pick it up and he picks it up and he takes a step and he goes right into the hole. Mm. So from me, OSHA is the floor. What's great about my practice is that 90+% of the contractors who we sue, they recognize that OSHA is the floor, and they also recognize that they want to do better than OSHA. And so the issue is in the case when they create a safety program and they create job requirements that are stricter than OSHA, then we use those requirements to say that's your job. And to a person, they have to admit that, yes, that's the standard by which my company has to live by. And why? Because we told the owner when we wanted the job that these are our standards, and we can incorporate those standards into our contract, right? Mm-hmm. And so once they incorporate those standards into their contract, that becomes their contractual duty to abide by that.
100%.
And OSHA, if that doesn't happen, OSHA is, at the very least, is the floor. Mm-hmm. And so oftentimes I have fun by saying, not only did you not meet your own standards, which are obviously stricter than the OSHA standards, mm-hmm. but you didn't even meet the OSHA standards either. So what are we doing here, right? And again, after I get them to admit that these are the standards to abide by, and once I prove to them that they didn't even meet the minimal standards, all of a sudden the defense lawyers want to talk about trying to resolve the case.
I love it.
Yeah.
You mentioned your law firm has strong connections with unions and organizations that advocate for workers' rights. Can you elaborate on why these relationships are so important for your practice?
Sure. So first and foremost, getting back to that human basic level, I mean, it's not even a belief. I think it's a universal truth that, my background as one of my clients essentially, creates an environment where we can connect, right? They understand and they believe that I am sort of one of them, right? And that's how I was fortunate, right? That's the way I was raised. And that builds trust right off the bat, right? In the very early part of my career, fresh out of law school, would have a union carpenter call me and say, at the point in time where it comes to like trying to promote yourself to get the case, I'd have to a person, in the first couple of years of my career, stop, you're Franny Laffey's kid. I get it. I know you're going to work your tail off for me. I know, so that was invaluable. And then as my career progressed, of course, I maintained that ethos. I maintained that culture because that's who I am. But in the ensuing years, I really crafted my skills and honed them in and, made a name for myself. I'll say that as modestly as I can. And so, early on in my career, someone encouraged me to be a two-headed monster, right? It's to bring in the business by virtue of my pedigree, but then also take that and make a name for myself. And, I modestly say I feel like I've done that. And so connections with the trades are hugely important. It's that trust thing. But in addition to that, because of that trust, like I'll have relationships and friendships, true friendships with leaders within the various trade organizations. And oftentimes these business agents or elected officials within the union are in a position to make recommendations. They're elected and they're leaders, and someone who's injured goes to them to seek advice about what to do. And I've been fortunate enough to gain the reputation, where they feel comfortable recommending me and my firm. They've also extended so many opportunities to me to address their membership. And this is where I feel most proud of, because I'll go to their membership and talk about workplace safety and talk about trends that affect their particular trade. Just recently, I was fortunate enough to address the carpenters union, certain members of the union who were undergoing training to become superintendents on the job. And the superintendent position is by far and away the most important role on a job, because in essence, the law requires them to have eyes and ears behind their heads, to be proactive as proactive can be, looking for unsafe acts, looking for unsafe conditions. And when they are spotted, they are to be dealt with and eliminated, right? And what I found in talking to these people in training is that, and people out in the field, is that for starters, these superintendents who are tasked with this awesome responsibility, they don't even know what their duties were because no one even gave them the contract, right? Nobody gave them the blueprint. This is what's expected of you. And so I show them clip after clip after clip of depositions that I've taken on videotape, where I've shown the superintendents the contract and they say, I had no idea I had that responsibility. So you have a guy out in the field who's tasked with preventing accidents, and he or she had no idea that that was their responsibility. So I think that that's a recipe for disaster. And so I tell these students, ask for the contract. If you don't get it, just assume that you are the person on this job who has to make sure that all the men and women on the job go home safe every day to their families. And that's, so it's really about access. The relationship with the unions is definitely a two-way street. We support their causes, and they have been gracious, of course, after carefully vetting my reputation and my skills, allowing me access to them to raise awareness and to really advise them of their rights. I know this sounds long-winded, but much to my surprise, many members presently in the trades don't even know what a third-party lawsuit is. They're very much aware of workers' comp, right? So when I go and speak to them and I say, listen, when you get injured, you have a workers' comp claim, of course, but you may have a third-party case. And that third-party case doesn't have a ceiling, right? In workers' comp, you don't get damages for pain and suffering in the past, the present, and the future. You don't get damages for your future earning capacity in workers' compensation claims. It's just a very formulaic thing. How much did you make for the last couple of months before your accident? And it spits out what they pay you biweekly. And then you get your medical bills paid. But you don't get the stuff that, really has no, only a jury can determine the value, like pain and suffering. And so the stakes are much, much higher. But they don't even know that. So all of a sudden, I go to speak to them about all of their rights that stem from a workplace accident. And their eyes open wide, and they wait. Some of them say, "I wish I met you a few years ago. I sure could have." And I said, "Yeah, I really wish we did meet a few years ago." But to make a long story short, it's about education, and it's about, once we vet their case and investigate it, and if we green light it, it's, making them our top priority.
Jeff, how do these partnerships with unions and organizations that advocate for workers' rights help ensure that workers are protected both on and off the job site? Could you provide examples of how collaboration with unions has benefited your clients?
Sure. This is probably an unpopular answer among my lawyer brethren out there. And what I mean by that is we do excellent work, and our results hopefully will be a sufficient incentive alone for contractors to change their attitude towards safety, right? We do our best for that to happen. I've had some personal experiences where I've grilled a person for 8 hours in a deposition, and then our paths cross down the line, and we have a very healthy conversation where that person says, "I want to thank you, like this accident and the way you represented us really made us take a hard look at our policies and our attitude and our culture as it relates to safety." But it's not lost on me that as we speak, there's some poor guy being exposed to an unsafe condition on a job site, because sometimes safety requires time and sometimes safety requires money, right? And that's not very popular sometimes when you're up on deadlines, right? And it's not very popular when you're trying to budget a job, right? So I don't hold myself out to be the person or entity that's going to eliminate unsafe practices on a job. I know my limitations, and I'm very pragmatic about it. I'm a realist. We could represent and have represented people who are catastrophically injured in motorcycle accidents or car accidents. It doesn't mean that that's going to affect every driver who is going to be, rushed going because he's late for work and driving like a maniac, right? These things are going to happen. But from my perspective, I have seen firsthand how our work has resulted in a cultural shift among certain companies. And listen, I say this without sounding like too dreamy or too ideal. Nothing makes me happier than to hear that stuff, because at the end of the day, I don't want to meet people who are catastrophically injured. I'll gladly switch careers if somehow safety, comes in and is at the forefront of every employer, every contractor on a job site. Because if that does happen, many, many, many accidents would never happen. But again, I'm very real, and I understand that as I'm speaking, there are thousands of jobs out there that are accidents waiting to happen.
In addition to legal representation, what role does your firm play in advocating for system changes in workplace safety and workers' rights, especially considering that you've been practicing for such a long time?
Yeah. So again, I've sort of touched on some of the examples, with respect to the training that we provide on workplace safety, the education that we provide as it relates to what their workers' rights are. That training really is, as I mentioned before, focus solely on the decision makers, the superintendents, right? So I think they walk away from that training understanding like, hey, I got a very important job. My job affects the safety and the health and welfare of all the men and women on this site. Safety absolutely should be my number one priority. And then in addition to, the tried and true methods of spreading awareness, I mean, we obviously back political politicians who, are in favor of OSHA, expanding OSHA. There's a trend right recently now where there's I forget what state, but there's a senator from some state who introduced a bill to abolish OSHA. So you have to look at that and say, well, where do your values lie? I mean, these are just minimal standards. And so we do our best. We align with organizations and support all of their causes that stand for safety and stand for accountability. And there's a lot of them over the years. But again, you're just talking to a pragmatist. Like, I don't think I'm going to change the world. I think I have to do it one contractor at a time. And I know that to be true. And I've spent 27 years doing it, and I'm going to stick to it. I don't think that I can give myself credit for changing human attitudes when it comes to balancing, the value of profits over safety. It's going to happen. That's never going to be lost on me. But one contractor at a time, that's where I'll make my gains.
That's wonderful. Jeff, do you have, and maybe you could share one or two stories, from your experience that highlight the impact your firm has had on the lives of injured workers? And in that story or those stories, what were the challenges that you faced, and how did you overcome these challenges?
Wow. Yeah. So there's a lot of challenges in all of my cases, but I guess I'll speak about one or two of them because they were somewhat recent. So one case that I'm particularly proud about is it's what I call like a legacy case, right? And I'll explain why. So I had the pleasure and honor of representing a union carpenter who fell through what they call a Baker scaffold. Back when my career started, a Baker scaffold is essentially a scaffold. Everyone knows a scaffold that's mobile. It has wheels. It's usually 6 feet length, and it's very, very useful on construction sites. Problem is that the manufacturers make a really crappy product, if you ask me. It's very cheap. It's very flimsy. And essentially what they do is they have a platform that the person stands on, and they only have 2 clips that rotate on top of the platform to keep it from popping up, right? I could sneeze on one of these clips and it would rotate, right? Or a worker's boot could make inadvertent contact with it and it would cause to rotate. When I mean rotate, it would literally rotate to the point where it doesn't serve its purpose in holding down the platform. So a worker then feels as though he's done in that area, and he wheels the scaffold from point A to point B to point B to point C. And after that thing rotates and it doesn't serve a purpose, especially in outdoor settings, they're going over rocks, pebbles, they're going over wires, and it's boom, boom with these wheels. Next thing you know, the platform pops up, but it doesn't pop up so crazy where anybody can see it. It just subtly pops up. And then the next time that person gets up onto that platform, you're dealing with a platform that's already popped out of its place. And then the moment that worker pivots or changes his weight, shifts his weight, the thing moves up and drops like a trap door. And that I've been handling those cases my entire career. I remember my first year, this is when these scaffolds didn't even have anything to prevent the platform from popping up. What they all did was take a shortcut and, again, use subpar methods to secure the platform. And we were able to demonstrate that this was a defective product, and this was a products liability action. And we made a very nice, we got a zero offer, and we went to trial. And when all said and done, we recovered over $3 million for our client. That
Congratulations.
said, thank you. That said, they took the issue up on appeal. The trial court was asked to reconsider their rulings. We survived that level. They took the issue up to the appellate court, the Superior Court in Pennsylvania. We survived that as well. Then only 6-point-something% of cases are picked by the Pennsylvania Supreme Court to review. Sure enough, as luck would have it, also adding to the gray hairs in my head, they took this case to take a look at the law in Pennsylvania regarding products liability. Now, at the time of the verdict, admittedly, the state of the law in Pennsylvania as to products liability was in flux. And so I understood the reason why they took up this case. But I applaud the jurist on the Pennsylvania Supreme Court. The issue in this case was, could a manufacturer come in to court and say, we followed all of the rules in the industry that led to the design of this product? And the Supreme Court said, listen, that argument really goes to whether you were reasonable or not in the design of your product. But that's not what products liability law is. Products liability law is you maintain laser focus on the product. It doesn't matter that you were reasonable. It doesn't matter that you followed the rules, so to speak. It matters is when all that is said and done, is the finished product, the product at issue, was that defective? And let's talk about the standards by which a jury makes that determination. So the biggest fear, and by the way, most states allow this evidence, but that's why I applaud the Pennsylvania jurors, because they said, listen, here's what's going to happen. These companies are going to come in and they're going to say, listen, don't blame us if you have a problem with our product. We followed the rules, right? And understand, 10 times out of 10, as a plaintiff's lawyer, you want to pick a jury who are rule followers, right? Sure. We want the jury to follow the instructions given to them from the court. We want the jury to look at the evidence and say, hey, defendants, you promised to do X, Y, and Z on this job, and you didn't do it, and we're going to hold you accountable. We want rule followers, right? So the problem is that if the law changed and allowed manufacturers of products to come in and say, essentially, don't blame us, blame the people that made the rules, which, by the way, are the companies that make the products, then the case wouldn't be about the product, it would be about the industry. And the court said, no, I don't care all the reasonableness you put into the design of this product. At the end of the day, your sole focus is on the product and whether or not it was defective. And so I received an early Christmas present at the end of 2023 when the Supreme Court released its opinion. And, you know, modestly, later that day, I was at my client's house celebrating him, shooting him with all this confetti and balloons and just celebrating this victory. And it was a victory not only for my client, but literally every Pennsylvanian who's injured by a product, right? I mean, the importance of this Supreme Court opinion, of course, is, you know, it affects everybody going forward. So when I'm long gone and some young buck says, well, Your Honor, that's not admissible under the Sullivan opinion, I'll hopefully get a itch in my nose or something when I'm sitting on a beach someday. Right? So I'm very proud of that. That's a legacy opinion. And I know I probably talked too long, but there's another client that comes to mind. I mean, all my clients, what I'm very proud of is that a substantial portion of my clients go from clients to friends, right? Like we're buds. You know, we go to Flyers and Eagles games, the Sixers games. You know, I attend their kids' graduations and vice versa. And that's why I love my career. That said, one other gentleman more recently, unfortunately, lost his left leg operating a stand-up forklift, and it was another products liability case. And he had temporarily lost control of, and he was operating in a warehouse. He lost control. The wheel sort of slipped on something that was slippery on the floor, and he was headed into a column that was in the middle of the aisle. And the design of the forklift left the operator's compartment open. And what human nature takes over, the guy sticks out his leg to brace himself. But unfortunately, his leg got caught in between the pole and the product.
Oh my goodness.
And it resulted in the amputation of his leg. Now,
Wow.
There are hundreds upon hundreds of people who have lost their legs to the design of this product. And the forklift industry in many, many states have been successful defending this design. And I thought we just put together a hell of a case against the manufacturer, as well as the other entities. For instance, the irresponsible entities that allowed the design of the columns to be in the middle of the aisle, for instance, they were held responsible as well. But to make a long story short, another David and Goliath moment where I think we built such a strong case that despite the forklift manufacturer in question's success throughout the country, they backed off and we resolved that case globally over $8 million for this gentleman. And he's currently a friend as well. So just talked to him a month ago.
Oh, wow. Thank you so much, Jeff, for sharing these beautiful stories. I really appreciate it. And I know you have hundreds of them, but like you said, those were the most recent ones. Very, very interesting. For workers who might be listening and are unsure of their rights after an injury, what advice would you give them? What steps should they take immediately following an accident?
That's an excellent question, and I speak about this topic quite often. First and foremost, as I described earlier, the nature of our relationship is such that why not explore your rights if something serious happens to you? Oftentimes, someone will come into my office and say, listen, listen, in hindsight, I think I bear a lot of responsibility for this. And then I ask them questions. Well, how long has you and your crew been doing it this way? Oh, we've been doing it from day one. And when you were doing this from day one, was there a general contractor watching what you guys were doing? Oh, absolutely. Yeah. And did they do or say anything to stop you guys from doing this? Absolutely not. You know why? Probably, I would guess it's because we were rocking and rolling and getting all this stuff done really quick because we were taking these shortcuts. Light bulb moment. Okay. Well, let's go after that general contractor. Let's go after the other subs, not your employer, for what they may have done to contribute to this unsafe act. And so, to make a long story short, come in, explore your rights, doesn't cost you a dime, and understand that, safety is a shared responsibility. And so, and especially, it's easy for me to go into a court and say, let me get this straight. They want to make this all about my client, Johnny, here. But Johnny gets paid his hourly rate. Johnny makes too many waves about safety on the job. Johnny's going to get his walking papers. Well, what about this contractor who got paid a gazillion dollars to run this project? And the reason they were hired is these 10 pages of touting their safety record. So who's more responsible for safety? Who has the resources? Who's getting paid for safety on the job? It's the contractor. So who's more responsible? And in the last 27 years, that's been a common theme when in litigation, they try and point the finger at my client. And so safety is absolutely a shared responsibility. Our clients are definitely responsible for their own safety, but we have earned our mark in explaining to juries why these things happen. And the way in which we do it, a jury feels comfortable concluding that our client was essentially a puppet for the decisions that these big wig companies make to
Mm-hmm.
affect their safety. So
Mm-hmm.
yeah.
Looking ahead, Jeff, what changes do you anticipate in labor laws or workplace safety regulations that could affect workers in the construction industry?
Yeah.
How is your firm preparing to address these changes?
Sure. I mean, we do our best in staying, keeping our finger on the pulse, if you will, of
Mm-hmm.
all things OSHA. So I am aware, for instance, that what's likely to happen for OSHA to have more of a bite, right? I mean, understand, like, there would be fatalities on the job, right? And then OSHA would fine the employer and the other contractors responsible like $2,500. So I'm thinking to myself, is that really going to be an incentive? Like, that needs to change.
Mm.
And so there's an effort afoot within OSHA right now to sort of make their enforcement power have a little bit more sting. I mean, that's literally in the works now. That hasn't been enacted yet. They're also going to promulgate stricter standards as it relates to exposing people to like lead and other pesticides or other chemicals on the job. There's going to be requirements to have more strict ways in which you monitor the levels of these chemicals on the job. So yeah, OSHA's trying to have more bite, but that only will help promote safety, right? Because listen, the end of the day, the only incentive driving these contractors is the bottom line.
Mm-hmm.
If that $2,500 fine gets changed to now $100,000 fine, I think the contractor getting that $100,000 fine is going to be a little bit more proactive about safety going forward. And so we stay abreast of that to the extent people want our input and opinions on it. I'll climb the mountaintops and sing that psalm, so to
Mm-hmm.
speak.
Mm-hmm.
But yeah, let's not deal away with OSHA. Let's make it stronger.
Absolutely. And finally, what message, Jeff, would you like to convey to workers who may feel hesitant to seek legal representation after an injury? How can they empower themselves in the face of adversity?
Yeah, I mean, it's sort of, I'm sure I've addressed that in my previous responses. I mean, if I just try and come up with a clear-cut message, it's know your rights, explore them, and leave it to me and or my firm to find a path for you. And listen, if it ain't there, we tell them, right? If like, and there's lots, I've had to look widows in the eye and say, I'm so sorry, I can't help you because your husband who fell off a roof was employed by the only contractor on the site.
Mm.
You know what I mean? There was nobody else involved.
Mm-hmm.
And what I do, I can't sue the employer. That is strictly workers' comp. So yeah, it's what can we do is to say, listen, explore your rights. And if you want to be in a position to explore your rights, you can document things. So if you get involved in an accident involving a product, and find out who made that product, find out who has custody and control of that product. If you fell in an uncovered hole, everybody has their phone. That's a camera too. Take a picture of it, right? Document things. That'll certainly, that's a prime example of helping yourself, right?
Mm-hmm.
I had a deposition yesterday where the wife of my client, also my client, took pictures of her husband in the hospital, and he got injured. He sustained a facial injury that is not easy on the eyes when you see these pictures. And one of the lawyers had the audacity to ask her, why did she take these pictures? As if they were trying to plant a seed, like, was this for litigation purposes?
Mm-hmm.
And she handled it beautifully. She said, maybe there was going to be a day where I was going to be asked to describe in words what my husband looked like. And I would never find the right words to describe this. And here you go. Here are the pictures. So you see for yourself what the shortcuts your company took and what created this mess.
Mm.
And that was turned around in an instant. And it was like, you know, because what would have happened had she not taken these pictures is that at trial, she would be doubted and she would be questioned for why she didn't take pictures,
Mm-hmm.
right?
Mm-hmm.
And they would say, well, it's a shame you created this serious looking problem in your testimony, but you didn't think to take a picture of it, right? So, you know, take the picture. Take the picture of the thing that caused your accident. If you slip and fall on ice, get that picture. You know, and listen, it's, how do I put this? It's hard to do that after you've been injured, right?
Mm-hmm.
So what I hope is in our outreach, you know, we hit the ground running. We identify witnesses. We identify people on the job who were in a position of control and authority. And to the extent that we're allowed to contact them, we do. We make them our allies as soon as possible. They get us the information that we get because our client may have been rushed to the hospital.
Mm-hmm.
And so it's about acting quickly. And if we can act quickly and aggressively and have a client recognize that, hey, maybe we need to pursue our rights here, and they make that decision promptly, it's a beautiful recipe for, you know, capturing all the evidence that we're going to need for the next 2.5 years while we're battling in litigation.
Mm-hmm. Thank you so much for all these great tips, Jeff. Again, this was so great. I hope our discussion about the comprehensive understanding of Jeff Laffey's work, the legal landscape of workplace injuries, and the importance of advocacy for workers' rights was informative and educational. And as promised, here's a fun pop question for you, Jeff. Are you ready?
I hope so.
Let's do it. What book, podcast, or resource has had the biggest impact on your personal or professional growth?
Wow. Well, sticking with the theme of recency.
Mm-hmm.
So I a huge Philadelphia sports fan, and probably first among them is the Philadelphia Eagles, our recent Super Bowl champions.
Woohoo!
And
Congratulations on that. That was amazing. Wow.
You know, you have to be a Philadelphia. Like, I look at my daughters, who's 15, and I said, you've been alive and seen the same amount of championships that I have in my 50s, right? So it's like, it's not fair, but you're
not
at least,
all.
yeah, right. So we've suffered for decades. And it's so nice when that happens. And not to brag, but it was definitely a bucket list moment. I went to the Super Bowl.
Wow.
You know, having a cool wife that allows me to make a split decision and go with a buddy was just unforgettable. But the reason I say that is because of the Eagles and the recency in the weeks leading up to the Super Bowl. I think it was definitely in the playoffs, but we had our star wide receiver. He went to the sidelines because the defense was on the field. And usually you huddle up among your teammates to talk about what you're going to do next when you get out on the field again. His name's A.J. Brown. He's a star wide receiver. And he went to the sidelines and he was reading a book, and like it became the news of the town. And the book was called Inner Excellence. I think the author's name is Jim Murphy.
I'm writing that down right now.
Yeah. And the reason I say that is because I'm thinking to myself, why would some star wide receiver jock type guy start reading a book about inner excellence during the game? And he was getting like negative reactions to it. So I said, you know what, let me see what this is all about. And boy, you know, and I'm the type of guy, I don't follow, and maybe I should, a bunch of like books and podcasts that deal with like the legal space. You know what I mean?
Except it's time for more injury funding, right?
Yeah, there you go. And yes, we absolutely do that. You have a new subscriber for sure. That said, I like, and what I'm motivated by is, you know, I have to invest in myself, right? In order for my clients to come to me and put their trust in me. And so this it was very informative and very influential and inspiring to me, where he really focuses on the journey and what is winning. Is winning like you get money so you can buy a car, or is winning, you know, the journey, right? Is the journey of, taken and what it was like he was speaking to me, because it was like, this is a guy who says winning isn't like the result. Yeah, it includes that, but it's the journey, it's the ups and the downs, it's the challenges that you're faced that makes you, hopefully learn a lot about yourself. It hopefully makes you want to improve. It allows you to identify areas of improvement. And it also gives you, that journey gives you resolve. And the more you go up and down in that journey, the stronger you are. And the stronger I am for my clients, the better I'm going to do for them, right? And the more they're going to feel like they had a companion and a friend along the way. And so,
Absolutely.
there's a lot of like self-help books and all that stuff. And it's about stress management. I mean, I've earned every single gray hair in my head. I'm glad it's in my head instead of falling off of it. But nevertheless, and I take a lot of ribbing from my friends who either dye their hair or just are lucky enough to not have it. But that said, that was the most inner excellence. And I have about a 50-minute commute to work. And oftentimes I put that on the Audible, and just play it. And that's about I'm probably second, 2.5 times into the book. It really has some nice messaging. So I encourage it. But all my Philadelphia listeners will appreciate the origin of how that book got introduced to all Philadelphians. And I encourage all Philadelphians to read that book. And for those of them who are critical of A.J. Brown for reading it, cross that off the list. It serves him well, and it will serve them well as well.
What a unique story. Thank you so much, Jeff, for sharing it again. And if anybody has a question related to construction injury or needs your help, how can they find you? Do you have a phone number, website, social media sources?
Maybe this is where I'll speak the slowest. Website, laffeybucci.com, Laff as in Frank, EYBUCCI.com. We have a website, all of our social media handles, Facebook, Instagram, LinkedIn, Jeff Laffey. We are located in Center City, Philadelphia, and the phone number is 215-399-9255. Thanks for the shameless plug. I didn't know that was coming, but I appreciate it.
I love it. That was attorney Jeff Laffey, president and co-manager partner at Laffey, Bucci, DeAndrea, Reich, and Ryan LLP, based in Philadelphia, Pennsylvania. I want to thank you all for listening and watching our story today. For more tips and tricks on legal funding and personal injury and law and medicine related topics, follow me, download, like, and subscribe. For It's Time for More Injury Funding podcast on several podcast platforms worldwide, and follow More Injury Funding on LinkedIn, Instagram, Facebook, Twitter, TikTok, Pinterest, YouTube, Google business profile, and my website at moreinjuryfunding.com. I can't wait to see you, my dear listeners and viewers, on my next upcoming episode. Tune in soon for our next guest. Until then, be well. Thank you.
Thank you.